So essentially I looked at it, what actually is law in the sense of enforceability. And law in the sense, okay, we used to physical laws like gravity and stuff like that, okay? I.e. a cause has a reaction, predictability, okay? So laws of nature. However, law in the sense of birthright or an unalienable right or inalienable right in English or American, law is the respective duties, rights and obligations between the consenting parties. So law, as Lord Diplock said, we need access to free courts, public access to courts, and the first job is to establish the duties, rights and obligations between the parties. So that's the first thing that should happen in every court case. Is there a lawful excuse to breach the other person's peace? So it's all very rational and sensible. And so it goes through then the same thing like we've done earlier today. I don't want to go through it all because it's, it's there. Every human's right to survival, i.e. we have the right to defend ourselves as we feel best to do it. We have the absolute right to choose what we do with our body. And yesterday we discussed abortion. Abortion is probably the most complex issue with this. We've discussed with our mind how we deal with a loss of the mind. And abortion, the only rational way to do that is the mom knows who she slept with, or may know. There's a high probability the mom knows who the father is than the father, okay? And therefore, ultimately, it's a decision of the mom. It starts off as a joint decision of the masculine and feminine, and if there's a dispute, the overruling must go to the mother, because she's the one that goes through the work. And who am I to say whether her decision's right or wrong to abort a child? There's so many factors. It's a personal decision, nothing to do with me or nothing to do with everybody else. It's not a political issue. We should not be wasting all of this time in public dealing with it. And so, whatever you do, if you want to smoke weed, if you want to do this, if you want to hang yourself, whatever, it's your choice. Go ahead and do it. Nobody has a right to stop you doing that. And nobody has the right to stop you causing yourself harm. How do we know that? There are a lot of physical contact sports where the law accepts, through consent, you can have yourself harmed. So how on earth does anybody think that can stop you from voluntarily harming yourself? It's all well covered in law. And now, natural justice is, all courts are meant to be courts of conscience, okay? They sell you this thing, no, we're not courts of morals, morals is conscience. We are courts of law, okay, i.e. procedure. Remember, equity is fair. What do we feel is fair, and is there a just outcome? There's two parts of it. So what they're describing is the justice system. Yes, the justice system is a tick box. Have we done, have we done, have we done, have we done? Have we acted in accordance with the rules of what the court rules are? Okay? So when they say, and this was very well quoted, we're not courts of conscience or morality, we are courts of justice. And that is the first bullshit claim, because Earl of Oxford case, 1615, so 400 and something years ago, we settled. Every court is a court of conscience. Equity prevails. Okay? So, utter rubbish, but it's got this drilled into so many people. So,
what was that act? 1615.
Earl of Oxford case, 1615. That's how you invoke equity. Equity is invoked when anything goes against the conscience, and you can force the court, because lower courts are bound by higher court decisions, which is common law precedents, the judicial system that we have meant to have in this country. That means every single court must have equity. But if you don't stand on your right to equity, you don't give it equity, which itself is causing harm. Okay, The lawful authority of the independent judiciary. So this is page 12 in the manual. And basically we went through and spent some time yesterday. The first promise is to govern. The second promise is the creation of an independent judiciary. The first promise creates governance. Second one, independent judiciary. Governments, therefore, cannot tell judiciary what to do. Judiciary cannot tell governments what to do. Okay. Now, we went through I mentioned the Constitutional Reform Acts 2003 to 2005. That separated, it finally separated the House of Lords, i.e. governance or Parliament assembled, and moved total independence to the courts. The Lord Chancellors, and in the courts, they've got this little, okay, here, I'm Mr. Judge, okay, and there's a little thing above my head, coat of arms, okay? That's the Queen in court. I'm the judge who's made my oath to the Queen, or King coming, okay? Therefore, the judge is the agent of the Queen to deliver the Queen's promise. And her promise is to deliver cause justice in, what was it? Will you to your power cause law and justice in mercy to be executed in all your judgments? So that's the job of the dude sitting on the bench. Law, we looked at and said, law is our birthright. So that goes through the Act of Settlement 1700. Now, firstly, they make the oath to the monarch through the Crown, and the Crown keeps an eye through because there's spy cameras in all of these coat of arms. And the oath is to cause law, and therefore there's an obligation to serve the monarch to uphold law. And they affirm in their oaths, I will act according to law. So that is the contract with the people. That's what we expect, or we will be demanding we get now when we go into court. Not whatever they want to do. Okay? We need to hold them to account to it. So people have been asking the court judges like that, you know, are you acting under your oath? Okay? You know, you sitting on this chair, okay? Of course I'm frigging about acting under my oath. What do you think I am? I'm a judge. Okay? So, but they get pissed off because they've got this aloofness and...
Well, why don't they admit it then? Why don't they just simply say yes?
Correct. Why? Because it goes against their conscience. They know what they're doing is not right. Okay, and therefore, we've got to force them into acting under their oath. And so, and so this is something that we've really been learning with going into the courts recently. So last week in the council tax thing with Lance, basically we gave judicial notice to the bench of the Bill of Rights, Coronation Oath Act, and Act of Settlement. Okay, because that's one of our primary argument about no lawful cause of action. And what happened basically, they ignored us. So, why did they ignore us? Is it because we lay litigants, we lay people, and we're not officers of the court, and it's up to the officer of the court, the clerk, to say to the bench what they interpret the law to be? Okay, so we judicially noticed the bench. So what we're doing now, the next time we're going to court, what we're going to do is judicially notice the clerk and say, clerk, can you confirm to the bench that the Bill of Rights is current statute law?
And as you're doing that, are you giving them a copy of the
Yeah,
Bill of
we give them a
Rights?
copy. A simple yes/no question. Can you confirm to the bench? Yes, Your Honours, the Bill of Rights is current statute law. Okay, and this way, through the officer of the court, the bench now must listen to it. Maybe that's the solution, I don't know. Okay, but do you see how it may have helped us?
Yeah.
Okay, so basically we do that for the first, all three. Can you confirm to the bench the Coronation Oath Act is current statute law? Yes or no? And if they don't answer the question, can you please verify now, go into legislation.gov and confirm, because you have an obligation to put them with the correct law. Can you do that now? So we're forcing the court to do their job, is what we're trying to do. And that's called moving the court. Okay. And so basically from what we've learned with all this council tax stuff is, and this will apply everywhere else, okay, with all cases. If we're doing it as lay people, why are they not listening? Now when you go through a solicitor or a barrister, forget it, they're not going to do anything like this, they're not there for your interest. They're there just, you know, let me get my paycheck.
If you have a district judge, then you can't go through that process because you can't ask the
You
judge.
can.
You can.
And this is the thing. The bench is neutral.
Yeah.
It doesn't matter if it's a district judge or high court judge or a magistrate. They're a neutral party to look at the evidence brought before them. Okay? And so, what we do is there's a district judge, we still go, Clerk, can you confirm to the bench that this is current statute law?
Right.
And if the district judge interferes, we need to control that. Hang on, here's your legal advisor, he needs to confirm to you. It's not up to you. Are you here representing the other side? That's bias, that's contempt of court. Okay? So we've got to control them and try and find ways of forcing them to do it. And they'll threaten you with contempt of court and all sorts. But we'll find a way to break through it, we will, there's no question about it. And so, everything comes down to the evidence. So the jurisdiction, what is jurisdiction? People say, I stand under common law jurisdiction. I'm the living man, I'm the living woman. You know, what does jurisdiction mean? Quite simply, does the court have authority to resolve the dispute? That's what jurisdiction means. Okay? So, jurisdiction, let me just see how I'm going to go through this first. Okay, so basically, in the courts, they've got a structure in order to allow specialist knowledge to be retained in a box. Okay, so you get divorce, you get family courts, you get intellectual property courts, you get trust courts, property courts, employment tribunal courts, blah, 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 blah. And the idea behind it is rational, it's for efficiency. Instead of having to reteach the judge about all of the different law every time there's a case, you just send them to the people where they've already got expertise in the matter. You know, it's like if you're going to have your house built, you go to a glazer for the window, you go to a brickie for getting the walls, you go to a plumber for the plumbing. You know, it's perfectly rational. But jurisdiction quite simply means, does the court have authority to settle the dispute before it? So, when you go in, if you try and bring a family matter into the magistrate's court, they'll redirect you, go off to the family court. And same thing with all of the court structure. We'll look at the court structure shortly. Okay. So jurisdiction is not, I'm the living man, I'm under God's law, I'm under this law, I'm under that law. Okay. It's about, can the court, does it have authority to deal with the matter? So landlords and tenants, landlords, hands up. Right, have you had any landlord disputes? Okay, have you checked your leases?
With the service, well, yeah, with the free.
Okay, in your leases, where does it say you'll resolve disputes?
Properties revenue.
Does it really? Does it really? Have a read. I bet you it says Royal Institute of Chartered Surveyors.
No, it doesn't.
Okay? Okay? The vast majority of leases say Royal Institute of Chartered Surveyors. So basically, if the parties do not go to that, I could argue if you took me landlord-tenant issue and my lease says Royal Institute of Chartered Surveyors, and you try and take me into the tribunal, okay, I'll say tribunal's got no jurisdiction. Prove it. Here, in my lease it says Royal Institute of Chartered Surveyors. Both of the leases of the properties we got the same Royal Institute of Chartered Surveyors. So what should happen is, the dispute should first be brought to Royal Institute of Chartered Surveyors. They may rule and say, Jesus, we're not interested in this crap. Go to the tribunal. Okay? So that's jurisdiction. Do we have authority to act? Okay? Basically, it's become common practice or custom that, yeah, RICS don't even question this, but they used to have that privilege. That privilege has become custom now, just to go straight to the tribunal. So, do you have a clear understanding with jurisdiction and what's the difference? When people are saying, I'm on common law jurisdiction, what are they saying in substance? What they're saying in substance is, the rules of their interaction on our respective duties and rights are created by the common law. Okay? So, there's not such a thing as common law jurisdiction. I can't invoke common law when I walk into the court. The common law is what I'm standing on for my rights, to support my believed rights. And when the common law is not sufficient, then I'm standing under the rules of equity, under the Earl of Oxford case, which says if the common law is not fair and just, I argue lawful excuse from the existing common law judgment under the rules of equity, and the court is obliged, it must follow the rules of equity, because the jurisprudence of the common law system is you, a lower court, do what has been decided before you by a higher court. So again, we're forcing the court to uphold the rules. Okay? Again, back to this, if you do not stand on your rights, you have none. Okay? They are knowingly causing harm by not keeping the peace. They have an obligation to do that. And they are making money out of you as a result of that.
So who's doing this? The courts, the councils?
Courts, councils, everybody, anybody. Okay? And this is why, let's go back to the basics, the foundation. Everything is a breach of peace. A breach of peace means you cannot knowingly cause another harm. Once you've been put with the knowledge that your actions are causing harm, or a reasonable person can see, it's self-evident to a reasonable person that your actions are causing harm, then you're guilty of fraud. Okay? However, we've been accustomed, the Queen said, I'll govern you to your laws and your customs. We've been accustomed to tolerating this nonsense. We are the problem. We need to grow up. We need to start holding them to account. We need to accept that we have let them go and get away with this nonsense. We are the solution. Stop blaming them. That's what kids do.
So if the Queen agreed to rule us according to our customs, and it's been the custom that we allow this to happen, doesn't the first person who dissents against it, they're not going against the custom?
No. Because the law is above custom.
Okay, thank you.
And somebody said to me the custom, basically, what the word custom means in law, I need to look this up, I don't know. Basically means something prior to living memory, which would make sense. But customs are changed, okay? Whereas the law actually is very scientifically derived through logic and applying scientific principles of evidence and applying logic. So law is not something that's irrational. Law actually is extremely scientific because you're searching for the highest truth based upon evidence. So jurisdiction, hopefully people are clear now. admiralty jurisdiction, you go to an admiralty court and they deal with it there because they have authority to resolve admiralty disputes. Family jurisdiction means you go to a family court to resolve family matters. They have jurisdiction to resolve family disputes. So are people clear what jurisdiction means? And why, when people stand up in front of the court, I stand on a common law jurisdiction, you're a bloody idiot, you don't know what you're talking about. Okay? However, the court should then explain to them in simple terms. It's their obligation. They must use simple language that anybody can understand, especially the person before them. They have an obligation to explain this to you. Okay? So, the point really being, we don't want to walk into courts anymore looking like idiots. Okay? We've learned, we've taken responsibility, we now are starting to understand and we're learning how to hold you accountable. Okay? Right, administrative courts. What's an administrative court? So that's page, I'm not going through the pages, okay, but if you look further, page 17. Okay? An administrative court is defined as a court or a decision of the court where the mind has not been applied to the evidence. Okay? So basically, somebody puts a piece of paper up a stamp.
So
Okay.
it's not obviously it's not a court of law then.
It's not a court of law, okay? Now, this goes back to justice. What is justice? Justice is the process of administering law. Okay? So justice is the system, the ticks box. Do this, then do that, then do that, then do that. Okay? So there's no law involved in simply just doing this, because what it says is, do this, read it, comprehend it, apply your mind. Yeah. Apply your mind? No.
So
Okay?
is it fair to say then that magistrates' courts can be both administrative
They are
and
administrative courts.
But is there a time when the magistrates' court is trying a crime where they do apply the mind, or they never do?
Okay, it depends on the cause of action. Okay? Victimless crime, there is no such thing, it's
So that's
oxymoron.
administration.
It's administration. Okay? If there's actually a victim, yes, then they'll apply the law.
So they can be both depending on the case.
Yeah, yeah. So any administrative court is unlawful. So basically, remember I was saying about the separation of the judiciary from governance and parliament? Okay? This one is so important for people to understand. The Parliament has created legislation about the judiciary. By the judiciary following that legislation, are they independent?
No.
No. So the problem with this is some of the stuff that Parliament puts out is pretty good. So the Senior Courts Act, 1981, Section 49 says, in the senior courts, you must apply equity. And in the County Court Act, 184, it says the same thing, you must apply equity. Okay? However, in the Magistrates Court Act, it says something different. It says nothing about equity, and it says you must apply Acts of Parliament. So, by them applying Acts of Parliament, they are admitting to be an unlawful administrative court. Therefore, everything that comes out of that is void. It has no lawful authority.
So if you've already had a liability order, because I didn't know how to follow all this, I can then sort of like spin it round and say, I believe this liability order is void, can I please have it removed?
Therefore, under your powers under Section 142, I give you the opportunity to correct your mistake.
So section 142 of the
It's
civics.
in the manual.
Oh, thank you.
In the magistrate's court, we were talking about some of the stuff in more detail. So basically, just continuing on with this, we first give them an opportunity to remedy. The question then is, what do we do thereafter? Again, we can go a year and a half down the road and be in the same shit, and nothing progresses. So we need to find a new solution. It doesn't work. Okay? People have been trying this freedom of the land stuff for decades. Look, a year and a half of trying to appeal doesn't work. The evidence shows me now already it doesn't work. Therefore, we must change what we're doing. Okay, so liability order example. I've put in the section 142 with the facts, and this is what we're doing with the council tax stuff. We're gathering the evidence, we put the facts, we put it back to them, and section 142 is, hang on a second, is not barred by time limits. Okay? Whereas the appeal process is barred by time limits, and if you miss the time limit, then they use that as an excuse not to continue and give you the right to appeal. Okay?
But equity should supersede that decision.
And it does, because when you put in an appeal, one of the sections is, are you out of time? If you're out of time, give us a reasonable excuse. Equity. So everywhere you look, equity's there. Okay? So the question then becomes, they're obviously not going to reopen the case because, oh my God, just imagine how much money they're going to lose if they stop this council tax stuff going through there. All those people losing their jobs and money and all of this stuff. So once we've given them the opportunity to remedy, guess what that is? It's our notice. We can then give them the second and the third opportunity, and then we've got the evidence to go to trial by jury of an indictable offence before a jury in the High Court through the private criminal prosecution process. That's where our remedy lies.
So what we're taking under private criminal prosecution is the judge for not responding to...
When, depending on the evidence, okay, so basically what happened with Lance's council tax case, the bench was advised by the clerk, in accordance with section 34(6), you need to consider whether you are satisfied the sum has become payable, has not been paid by the defendant. Okay, so here as the magistrate, my job is to get legal advice from the legal advisor. That's wrong. It's beyond, before the evidence presented before me. Okay? And so at a guess they would sit and argue and say, hang on, you're a layperson, what do you know about the law? The legal advisor has advised me to say, I've granted the liability order because I'm satisfied that some have become payable. So therefore, the judge is off the hook. We can't do anything against the judge. Okay? However, if we force the legal advisor to say the Bill of Rights is standing, the Act of Settlement has standing, and the Coronation Oath Act has standing, now they've got a problem. Because now they need to answer, according to the constitutional authority, is this legal, the council tax? So now, if the magistrates fail to address that evidence, then they're acting in breach of their duties, and then we can go for the magistrate. And also, with Lance's case, we judicially noticed the court. The legal advisor failed to direct the court what to do with that information. Therefore, we can go after the legal advisor for failing in their obligation to direct the court. Okay. Yeah?
I just wanted to say about council tax. I've heard, I haven't done it myself, but I'm going to attempt to do it. And I've heard of lots of people having success with it, lots being like 30, 40, 50.
Nobody has success with it.
Well, you don't know what I'm going to say yet.
Nobody has success with council tax.
What I'm saying is there's apparently rules handed down by government of what percentage of all the council's budget is supposed to be spent on like homelessness, this and that, and da da da.
Yeah.
and apparently Ellie Bray's one of them, and you literally, on each council's website, there's a thing that if they spend more than 500 quid, they have to like account for it. So if you scour through that, which probably takes
Yeah.
ages,
And
then
this
you go,
is,
they've written
sorry.
to the Valuations Office Agency, and then their property's been entirely removed from the register.
Yeah,
Then you don't
through
have to
the
deal with
courts,
court, you don't
nobody's
have to do any
won
of
it.
that. But if people have done that, then surely they should share that, and then like, you know,
Not
rather than
only,
just the individuals.
okay, not
get
only
their
should they
property.
share that, okay, we had bailiffs called off because there was no liability order, and we noticed them, okay? Hang on a second. Basically Marston's confirmed in writing that they've sent the files back to the council. Now the council's with that knowledge, so the legal fiction is with the knowledge, it can't enforce it because they can't show a liability order or a warrant of possession or control. Therefore, the file's gone back. Now, under the common law equal treatment and fairness tort, all of the files should have been handed back because the legal fiction is with the knowledge,
Yeah.
okay, and you are all agents of the legal fiction, therefore you all now need to send it back.
Yeah.
That's how it should work, this stuff, okay? Now, what you're talking about is the question of reasonableness. Okay, the biggest problem we've had with the council tax withholding program is guess what? Who's going to collect the rubbish? Seriously, that's the biggest criticism we've had. Nobody's questioned the legal arguments and lawful arguments, okay? Or whether the courts are actually doing their job or not doing their job. Who's going to collect the rubbish? Okay, so basically, as a landlady, you're familiar with communal charges, yeah? Therefore, what are communal charges? In effect, what you've got is the council is a trustee as much as a landlord is of the communal charges where each individual leaseholder puts money in towards the communal charges. And what you do is, as the landlord, you prepare a budget. This is what I'm expecting to spend on these different things. Except we have a right then to say, is this fair and reasonable? Whatever you're actually putting in there and actually spending. And that's what needs to be applied to the councils. So, because it's a public body and using public money, automatically they are trustees of the public money. Just like the landlord, you need to hold the service charges in a trust account, okay? Because you are the trustee and you need to account for that. And if there's anything missing, you are liable for that. So that is really the truth of what it is, okay? And so as trustees, we can always hold them to account. Hence, the problem is, yes, I can cook books, I'm great at accounting, I've done that for many years as well in between, and I can make any account say whatever you want me to say, and I'll get them. So we need people with that knowledge, like Rowan suggested about the DSRs, about these cameras. We need people to set up subgroups to get a format whereby we address this. Okay? But yeah.
Just wanted to say, in one of my cases, I don't have council tax, but I have business rates, which I don't pay on a couple of properties, and it's 80 grand on one of them, they're chasing me. When I went to the court, they had a chair at the bench, and I threatened the judge, or the bench, if you do issue the liability order, which you threatened me to, make sure you've got the backup paperwork to back it, because I'm going to sue your ass.
Yeah.
And that was over 3 months ago, and I know the fucking whisper.
Okay. Okay. Now we all got different styles. Colours. But it takes all sorts. Okay. I'm very
It's about substance, not food.
correct about substance, not form. Yeah. Okay. So Calvin's kicked the door when the judge and the court wouldn't let him out of the court until they let him out. Not something that I would do, but
I threatened to call the cops to have the judge arrested for false imprisonment when they locked the door, locked me in the courtroom. So I was kicking the door in front of the security guard. I said to him, you let me out. He goes, let him out. I said, you